Your landlord cannot legally enter your home without notice in most states. This isn't just common courtesy. It is a fundamental legal right that protects your privacy. Yet countless tenants face landlords who routinely violate this boundary. They might walk in unannounced for a quick check or show your apartment. Some even enter to perform repairs without warning, leaving you vulnerable. Many landlords operate under the assumption you simply won't know your rights. This assumption allows them to cross lines that are legally protected. Your home is your sanctuary. It is not public property for casual visits. This principle is enshrined in what's known as the Covenant of Quiet Enjoyment. It's a foundational concept in landlord-tenant law across the United States. But the specifics of how much notice they need actually depend on your state. Most states require 24 to 48 hours written notice before entry. This isn't a suggestion. It's often explicitly written into state law. Ignoring this notice period transforms a legal entry into a trespass. This can happen whether you are home or not, creating an unsettling feeling. So, what exactly are your landlord's limited rights when it comes to entry? And more importantly, what can you do to stop them from overstepping? First, let's talk about when your landlord is allowed to enter your property. They typically can enter for necessary repairs or maintenance work. Another common reason is to conduct inspections that are allowed by the lease. Showing the unit to prospective tenants or purchasers is also usually permitted. However, all these reasons come with a crucial condition: proper notice. The only exception is a genuine emergency, like a fire or burst pipe. Even then, they must prove it was a real emergency to justify entry. Otherwise, any entry without your explicit permission or proper notice is illegal. This includes showing the property on a whim or just checking in. Many states explicitly define what constitutes reasonable notice. For example, California's Civil Code Section 1954 outlines a 24-hour rule. Florida Statute 83.53 also mandates reasonable notice, usually 12 hours. New York, while less specific statewide, generally requires reasonable notice. This usually translates to at least 24 hours, depending on local rules. These specific laws provide tenants with powerful legal defenses. Understanding them is your first step towards reclaiming your privacy. Here's the critical twist. Many landlords deliberately skirt these requirements. They might claim an implied permission or disregard your objections entirely. They count on tenants being uninformed, afraid, or simply too busy to act. This is where your power truly begins. You have recourse. The first step is documentation. Every incident needs to be recorded. Note the date, time, and specific details of each unauthorized entry. Gather any evidence you can: security camera footage, witness statements. Even a text message from your landlord saying, "I'm coming over," is evidence. Next, send a formal written letter to your landlord immediately. This is known as a cease and desist letter regarding entry. Clearly state the specific dates of unauthorized entries. Cite the relevant state law that prohibits such actions. Demand that they comply with proper notice requirements going forward. Always send this letter via certified mail with a return receipt. This creates a verifiable record that they received your communication. The vast majority of landlords will back down once confronted with official action. They prefer not to deal with legal battles, especially when they know they're wrong. But what if they continue to disregard your demands and the law? That's when you escalate to official channels. Contact your local housing authority or tenants' rights organization. Many cities and states have specific agencies dedicated to tenant protection. They can mediate disputes or provide legal aid resources. You may even have the right to break your lease without penalty. Repeated violations can be considered constructive eviction. This means the landlord's actions made the property unlivable due to harassment. In some jurisdictions, you can even sue your landlord for damages. This could include emotional distress or the cost of moving. The key is understanding that you are not powerless in this situation. The law is often on your side, if only you know how to wield it. Your privacy is a right, not a privilege when you rent a home. Landlords are bound by specific laws that protect your dwelling. Don't let ignorance or fear allow them to infringe upon it. Remember, This information is for educational purposes only. It does not constitute legal advice for your specific situation. Always consult with a qualified legal professional for personal guidance. But the path to empowering yourself against an overreaching landlord is clear. Document every violation, send that certified letter, and stand your ground. Your home is yours. Make sure your landlord respects that. This small action can save you from endless future intrusions. Take back control of your private space today.